We got a complaint about someone matching your description, acting suspiciously near the stacks. That was it. No greeting, no explanation, no attempt to understand the situation before rendering judgment. Just a sentence that landed in the middle of a quiet Tuesday afternoon like a stone dropped into still water, and everything that followed rippled outward from that single moment in ways that would eventually reach the highest levels of federal law enforcement, cost one city more money than most people would ever see in a lifetime, and permanently change the way police officers in that state were allowed to write their own stories about what happened when they put their hands on someone. But before any of that, there was just the library. Central City Public Library on a Wednesday afternoon in late October had a particular kind of quiet that felt almost architectural, as though the silence itself had been designed into the building alongside the reading carrels and the water-stained acoustic ceiling tiles. The fluorescent lights above hummed at a frequency just low enough that you stopped hearing it after the first 10 minutes. And the air carried that specific combination of old paper and cold air conditioning that anyone who had ever spent serious time in a public building would recognize immediately: the smell of institutions of knowledge preserved in slightly damp conditions, of a place that belonged to everyone, and therefore in practice to no one in particular. From somewhere deeper in the stacks, the occasional muffled sound of someone rolling a book cart across linoleum drifted through the space like a distant tide. Leon Grant had been sitting at the corner table for exactly 3 hours and 14 minutes when Officer Brennan walked through the main entrance. Leon was 24 years old, a third-year student at Callaway School of Law, and he had chosen this particular table on this particular afternoon for the same reason he chose it every week. It was tucked against the far wall away from foot traffic. It had a power outlet within reach of his charger, and the angle of the light from the nearest window fell across his laptop screen without producing a glare. He was wearing a cream-colored hoodie, dark jeans, and the focused, slightly exhausted expression of someone who had been reading dense legal text long enough that the words were starting to blur at the edges. On the table in front of him sat his laptop open to a 40-page clinic memorandum, a thick canvas backpack that had seen better days, and 3 yellow manila folders arranged in a careful stack, each one stamped across the front with a bold red label that read, "Confidential Attorney-Client Privilege." His phone was mounted on a small, collapsible tripod beside the laptop, its camera facing outward, and on the screen a Zoom session ran with the audio muted, a precaution for the library's sake. On the other end of that call were 3 of his classmates and Professor Harland Webb, who had spent 11 years as a federal prosecutor before transitioning to academia, and who was at this particular moment leaning forward in his home office chair watching Leon walk through a case analysis with the attentive patience of someone who had seen the inside of a courtroom enough times to know when something important was happening. 3 tables away, a 9-year-old girl named Mia sat with her sneakers hooked around the legs of her chair, working through a worksheet with a green pencil that she kept stopping to chew on while she thought. She had noticed Leon when she first sat down, mostly because of the impressive stack of folders and the way he occasionally mouthed words to himself while reading, which she found interesting in the distracted way that children find adults interesting when adults don't realize they're being watched. Her mother was somewhere in the periodicals section. Mia was working on long division and not particularly enjoying it. The library was peaceful in the particular way that things are peaceful right before they stop being peaceful. Leon reached for his coffee cup, found it empty, and set it back down without looking away from his screen. He had no way of knowing that 2 minutes earlier, a staff member at the circulation desk had picked up a phone and called the non-emergency police line to report in. Her words, a young man sitting alone for several hours with bags he keeps moving around near the stacks, which was not what had happened at all, but which was the story she had told herself about what she was seeing and which would take on a life of its own the moment it entered the system. The sound of tactical boots on library hardwood is a specific and unmistakable thing, heavier than ordinary footsteps, more deliberate, carrying in each step a weight that is only partly physical and mostly institutional. The sound of authority entering a space and rearranging it simply by being present. Officer Daniel Brennan was 38 years old, 15 years on the force, and he wore his platinum blonde hair cut military short above his collar in a style that left no room for ambiguity about what kind of person he understood himself to be. His face had been trained through years of patrol work and the particular discipline that some officers develop as a substitute for emotional intelligence to reveal almost nothing, a smooth practiced blankness that he deployed the way other people deploy a smile as a social tool, and which had the effect, whether intentional or not, of making everyone he spoke to feel slightly off balance before the conversation had even properly begun. He walked with his thumbs hooked into his duty belt, a posture that projected casual authority in the way that only people who have practiced projecting casual authority ever quite manage, and he moved through the library without looking at any of the other tables, without scanning the room, the way an officer responding to an ambiguous complaint might reasonably be expected to do, without pausing to assess the situation from a distance. He walked directly to Leon's table. He stopped on the other side of it, close enough that Leon would have had to push his chair back to stand up comfortably, and he stood there for a moment without speaking, letting the silence do preliminary work before delivering the line about the complaint and the suspicious behavior and the description in a tone that was perfectly calibrated to sound reasonable while communicating something else entirely. Leon's fingers stopped moving over his keyboard. The adrenaline arrived in his chest the way it always did, a sudden sharp spike that compressed the world into high resolution and made everything slightly too bright. And he recognized it for what it was, and did what he had trained himself to do, which was to take one slow breath in through his nose and let it out through his mouth and bring his hands down deliberately flat onto the surface of the table, palms down, fingers spread in plain sight because he was a third-year law student who had studied use-of-force case law extensively enough to know that the position of your hands in the first 30 seconds of a police encounter could determine the trajectory of everything that followed. Officer Leon said, and his voice came out polite and tight at the same time the way a wire sounds when it's been pulled to just before its breaking point. I've been sitting at this desk for over 3 hours. I haven't been near the stacks. I'm studying. Brennan's posture shifted almost imperceptibly, the casual ease dialing down by a fraction, the blankness in his face hardening into something more specific, something that had less to do with neutrality and more to do with the particular irritation of a man who was accustomed to a certain kind of response and was not receiving it. He took a half step closer. 3 tables away, Mia set down her green pencil and looked up from her worksheet. Not because she understood what was happening, but because something in the quality of the silence had changed in a way her body registered before her mind did, and she sat very still watching the long division completely forgotten. "I didn't ask for your schedule," Brennan said, and the polite phase was definitively over. "ID now." Leon knew with the precise and detailed certainty of someone who had spent 3 years studying exactly this category of law that his state did not have a stop-and-identify statute that required a person to produce physical identification without reasonable articulable suspicion of a specific crime, which meant that someone matching your description acting suspiciously was not legally speaking sufficient grounds to compel him to hand over anything at all. He knew this the way he knew the elements of a Fourth Amendment violation, the way he knew the difference between a Terry stop and a full custodial arrest, the way he knew the precise language of a dozen landmark cases that all pointed in the same direction. He also knew with the equally precise certainty of someone who lived in the body he lived in that knowing the law and saying the law to an armed officer in a public library were 2 entirely different propositions, and that the gap between them was a place where a great many bad things had happened to a great many people who were also entirely in the right. He said it anyway. "Officer, with respect, am I being detained?" Brennan's jaw tightened in a way that was very small and very visible. "Yeah," he said flatly. "You're detained. Hand it over before we do this the hard way." "If I'm being detained," Leon said, keeping his voice at the same steady register, his hands still flat on the table, I'd like to know what specific crime you suspect me of committing because sitting in a public library and studying for 3 hours isn't a crime." On the Zoom screen, Professor Webb had stopped taking notes. He was leaning forward with both forearms on his desk, his reading glasses pushed up onto his forehead, watching the feed with the focused attention of someone who had spent 11 years in courtrooms identifying the precise moment when a situation became something that needed to be documented very carefully. He didn't reach for his phone yet. He watched. Across the table, Darius, one of Leon's 3 classmates on the call, had opened a new browser tab and was typing the name of the library and the intersection into a search field, his fingers moving with quiet urgency, a person beginning to assemble information before he fully understood why he needed it. Brennan issued his final warning in a voice that had shed its remaining pretense of procedural courtesy, and Leon sat for 1 full second in the specific silence that exists between a decision and its consequences, looking at the officer across the table, then down at his laptop, then at the 3 manila folders with their red stamps, then back at the officer before he made the choice that he had in some sense been preparing to make for 3 years. "I've verbally identified myself as a patron of this library." Leon said, his voice no longer shaking, the tightness in it replaced by something quieter and more deliberate. "Without a lawful basis for this detention, I'm not providing my physical ID. If I'm not under arrest, I'm going to pack up my things and leave." And then he did the most ordinary thing in the world. He reached out and put his hand on the edge of his laptop lid to close it. That was the moment. Not the refusal to produce ID, not the legal questions, not the 3 hours of sitting at a library table. It was that single mundane gesture, that entirely normal action of a person preparing to leave a public space, that reorganized everything in Brennan's mind from a conversation he was losing into a situation he needed to control. In that reorganization, closing a laptop became attempting to flee, and fleeing was something Brennan knew exactly how to respond to. Mia had stopped pretending to look at her worksheet. She was watching openly now, her green pencil held motionless between 2 fingers, her sneakers very still around the chair legs, with the wide and unblinking attention that children give to things they don't understand, but instinctively know are important. "You aren't going anywhere," Brennan said. And then he crossed the distance between them in a single motion that was too fast for the word "walked" to quite contain. His gloved hand, heavy, closing hard, clamped onto the back of Leon's collar, the cream-colored hoodie bunching under the grip, and he yanked upward and forward with a force that pulled Leon half out of his chair, before the motion reversed and drove him the other way, Brennan's full body weight behind it slamming Leon's chest into the edge of the heavy oak table, with an impact that sent a shudder through the entire surface and knocked the small tripod sideways. Leon's phone skidded off the edge of the table and hit the hardwood floor. The screen cracked across the corner in a spiderweb pattern. The green recording light stayed solid. The phone had landed on its side, and the wide-angle camera, now resting at floor level, framed a rectangle of the world that included Brennan's tactical boots and Leon's legs and the underside of the oak table, and approximately nothing else, a strange, low, accidental composition that happened to be capturing everything. Miles away on a laptop screen in a home office, Professor Harland Webb watched his former student get slammed into a table in a public library, and he stood up from his chair, and he turned away from the screen, and he picked up his phone, and he dialed a number that had been in his contacts for a long time, belonging to a person he had not needed to call in several years. Darius, watching the same feed from his apartment, did not stand up. He opened Twitter. He began to type. "My classmate Leon Grant is being arrested right now at Central City Public Library. We are watching it happen live on Zoom. He has done nothing wrong." His hands were steady in the way that hands are sometimes steady when a person has moved past shock into a kind of cold, purposeful clarity. Mia pushed her chair back from the table. She stood up. She did not run. She just stood there, very small, with her green pencil still in her hand, watching Officer Brennan force Leon Grant toward the floor with a knee driven hard into the back of his thigh, and her face held an expression that no 9-year-old's face should ever have to hold. The particular look of a child watching an adult do something that the child already knows at 9 years old is deeply and fundamentally wrong. Leon made a decision in the fraction of a second between the knee hitting the back of his thigh and his body beginning to go down. And it was the decision that a person makes when they have read enough case law to understand that the most dangerous thing you can do in this situation is give your body's instincts permission to run the show, because your instincts, perfectly reasonable and entirely human, will tell you to pull your arm away from the joint lock before it tears, will tell you to catch yourself with your hands. Before your face meets the floor, will tell you to resist. And resistance, even the purely reflexive and self-protective kind, will be written down later as the justification for everything that is being done to you right now. So instead of resisting, Leon went completely limp. Not the limp of unconsciousness, but the deliberate, total muscular surrender of a person choosing to become dead weight, letting his knees buckle fully, dropping his center of gravity toward the floor in a controlled collapse that neutralized the joint lock by removing the tension that made it dangerous, taking away the leverage that Brennan's grip was designed to exploit, and landing on the library hardwood in a heap that offered absolutely nothing to push against. "I am not resisting," Leon said loudly and clearly, pitching his voice with the specific intention of making sure the microphone in the cracked phone on the floor could hear every syllable. "I am not resisting. My hands are going behind my back." "Stop pulling away!" Brennan shouted back, his voice at full volume, now delivering the standard use-of-force commands in the sequence he had recited hundreds of times. A sequence that was designed to create, for anyone listening, the impression of a suspect actively fighting against restraint. Commands that had no relationship whatsoever to the limp, entirely still person beneath his knee. The handcuffs came out. "Shashihi." The ratchet mechanism clicked in the quiet library with a sound that was small and metallic and somehow enormous. The sound of something being made official in a way that couldn't be easily undone, and the cold steel bit into Leon's wrists as the cuffs locked shut, and Brennan hauled him upright by the chain between his wrists, and Leon came to his feet with his chest heaving and his left shoulder burning from the angle of the initial grab, and he looked straight ahead at the wall of the library rather than at any of the faces turned toward him from the surrounding tables. Because looking at those faces, a dozen patrons frozen at their seats, some with their mouths open, some with their hands partway raised as though they had considered doing something and then thought better of it, would have made it harder to stay in the place he needed to stay. Brennan pushed Leon into a nearby wooden chair and turned immediately to the table. He grabbed the canvas backpack and yanked both zippers open in one rough motion and plunged his gloved hands inside, pulling out a textbook, a laptop charger, 3 highlighters, and a granola bar, and scattering all of it across the oak surface with the brisk efficiency of someone who has done this enough times to have stopped thinking about what it looks like from the outside. "Officer," Leon said from the chair, his voice no longer shaking, but tight in a different way than before, the tightness of someone maintaining control through active effort rather than through calm. "I don't consent to a search of my bag." Brennan didn't respond. He reached deeper into the backpack and came out with the 3 yellow manila folders, which he tossed onto the table in a stack, and the stack landed at an angle that spread the top folder slightly open enough for the red stamp on the cover to be clearly visible to everyone in the immediate vicinity. "Confidential attorney-client privilege. Those are confidential legal files," Leon said, and now he raised his volume deliberately, not to shout, but to carry, to make sure his voice reached the phone on the floor and the people at the surrounding tables and the body camera on Brennan's chest and every other possible recording device in the vicinity of this moment. "Those folders contain client information from a legal aid clinic. You cannot open those without a warrant." Brennan's thumb came to rest on the edge of the top folder. He looked down at the red stamp. He looked up at Leon. A brief flicker of something moved across his face. Not quite hesitation, not quite doubt, but something in that neighborhood, and then it was replaced by the blankness again, and he said quietly and mostly to himself, or perhaps mostly to his own shoulder-mounted microphone, checking for concealed contraband incident to lawful arrest, and he flipped the folder open. His eyes moved across the dense paragraphs of legal text, the client intake forms, the case notes, the confidential communications between a law student and the person who had trusted him to help them navigate the legal system, and he read a sentence out loud in the flat voice of someone performing thoroughness for an audience, a sentence that identified a client by name and described the nature of their legal situation, and the sound of it in the quiet library was deeply specifically wrong in a way that went beyond policy and beyond law into something more fundamental about what it means to be trusted with someone's private information. The camera on the floor recorded all of it. And then a small voice said, "Excuse me." Brennan looked down. Brennan. Mia was standing 2 feet away from him, holding up a single sheet of paper that had slipped from the open folder when he'd tossed it onto the table, a page that had skated off the edge and drifted to the floor in the commotion without anyone noticing. She was holding it out toward him with both hands, the way children offer things to adults with a complete and uncomplicated directness that has not yet learned to account for the complexity of the situation. "You dropped this," she said. Brennan looked at the page in her hands. Then he looked at Mia. Then he looked up at the room, at the 12 people at the surrounding tables who were all looking back at him, and at the paper in the hands of a 9-year-old girl, and at the open confidential folder on the table, and at the man in handcuffs in the chair. And for just a moment, the blankness on his face became something more complicated. Something that might have been the beginning of a recognition that he was standing in a story that was not going to end the way he had assumed it would. He took the paper. He closed the folder. He said nothing. If you've ever been in a situation where you knew something was deeply wrong but felt powerless to stop it, stay with our channel, because what happened next is the part that changes everything. The Central City Police Department's 4th District Precinct had a particular smell at the end of a day shift. Coffee that had been warming too long, industrial cleaning solution, and underneath both of those, something harder to name that had more to do with the accumulated weight of difficult human situations than with anything chemical. The overhead lighting was the flat, unforgiving kind that made everything look slightly worse than it was, and the rows of terminals where officers filed their end-of-shift reports glowed with a blue-white brightness that felt at odds with the hour. Brennan sat down at his assigned terminal at 5:47 p.m., logged in with his badge number, and opened a new incident report form. He typed methodically and without apparent hesitation, filling in the fields in the order they appeared. Location, time. Nature of complaint, responding officer. And then he reached the narrative section, the open text field where officers were expected to describe in their own words what had happened. The field that was supposed to be a faithful account of events as they occurred, and which was in practice something that officers with 15 years of experience knew how to use. He typed, "The suspect became visually agitated upon first contact and refused to comply with lawful commands. When this officer attempted to conduct a lawful identification check, the suspect swung his arms aggressively toward this officer, necessitating a physical takedown to secure the scene and protect the safety of library patrons." He read it back once. He pressed submit. The confirmation screen appeared. He closed the window, picked up his coffee cup, found it empty, set it back down, stood up, collected his jacket from the back of the chair, and walked out to the parking lot, and got into his patrol cruiser without stopping to speak to anyone. Without apparent concern, without any observable sign that he understood the particular fragility of the story he had just committed to writing. The holding cell had a concrete bench along one wall that was cold in the specific way of things that have been cold for so long. They have stopped being able to be anything else, and a drain in the center of the floor, and a light mounted behind reinforced glass in the ceiling that produced a steady yellowish illumination that made no concessions to the time of day or the condition of the people beneath it. Leon sat on the bench with his back straight and his hands on his knees. He was not panicking, which was not the same as not being afraid. He was afraid in the particular way that a person is afraid when they are in a situation that is demonstrably unjust and have no immediate ability to change it, a fear that lives in the chest and makes each breath feel slightly insufficient. But he had trained himself through years of studying the psychology of high-pressure situations in the context of learning to represent clients who were experiencing those situations themselves, to distinguish between the fear and the thinking, to let them exist simultaneously without letting the fear run the thinking. He sat and he thought. He went back through the encounter in the precise order it had happened: the complaint, the question about suspicion, the refusal, the laptop lid, the grab, the floor, the cuffs, the folders, and he tested each moment against what he knew. Checking the joints of it, looking for weakness and finding mostly strength, because he had said the right things and done the right things and kept his hands exactly where they needed to be, and the camera had been running and Webb had been watching and Darius had his phone and the green light had still been on when they walked him out. That green light was the thing he kept returning to in the hours before the lights out announcement came, and the cell fell into its nighttime version of itself, still bright, still cold, still indifferent. He held on to it the way you hold on to a specific concrete fact. When the larger situation feels uncontrollable, the green light was on. The camera was running. The Zoom was live, and Webb had stood up from his chair and turned away from the screen and picked up his phone. Webb had picked up his phone. Professor Harland Webb had called Marcus Reeves at 4:23 p.m. While the situation in the library was still technically ongoing, which meant that by the time Leon arrived at the precinct, Reeves had already sent one email and made 2 phone calls, and was sitting in his office with a yellow legal pad in front of him, writing down what Webb had described in the careful, structured way of a person who has spent 20 years turning chaotic situations into manageable legal arguments. Marcus Reeves was 46 years old, civil rights attorney, former ACLU staff counsel, and the kind of lawyer who had learned through experience that the window between an incident and the loss of evidence was narrower than most people assumed. Which was why the first thing he had done after hanging up with Webb was call the firm's technology consultant and ask him to contact Zoom about preserving the cloud recording before anyone with a reason to want it gone could make a request in the other direction. Across the city, Darius's tweet had been live for 4 hours, and it had traveled considerably farther than Darius had expected when he typed it, passing through the networks of law students and civil liberties advocates and local journalists, until it reached at around 7 p.m. A reporter at the Central City Courier who had covered police accountability cases for 6 years and who spent the next 2 hours making phone calls before filing a brief online item that went up at 9:15 p.m. Under the headline, "Law Student Arrested at Public Library. Witnesses Describe Violent Takedown." By the time Brennan sat down at his terminal and typed his incident report, the clip had been seen by more than 40,000 people. In the morning at the 4th District Precinct, an email arrived in the inbox of Internal Affairs Division investigator Sandra Hughes. It was from an attorney named Marcus Reeves. It contained a link and a single sentence: "I would encourage you to watch this before approving any incident report associated with the arrest of Leon Grant at Central City Public Library yesterday afternoon." At the circulation desk of Central City Public Library, the staff member who had made the call to the non-emergency police line sat in the break room on her lunch break and watched the video on her phone, and the color in her face changed in a way that was very slow and very complete, the way the color drains from something when it has been in the light too long. 3 months after the arrest, a windowless conference room on the 4th floor of the county courthouse smelled of burnt coffee and recycled air and the particular low-level anxiety of a room where people regularly made decisions they would prefer not to have to make. ADA Thomas Calloway slid a printed plea agreement across the table and tapped it twice with his pen in the way of someone who has done this particular motion enough times that it has become automatic. And he said that it was a noise ordinance violation, $150, all other charges dropped, and that it all went away that morning if Leon put his signature on the line. Leon sat with his hands folded in his lap and said nothing. Reeves didn't pick up the plea agreement. He unzipped a leather briefcase that had been with him through enough courtrooms that it had developed a particular kind of authority of its own. Worn at the corners, the leather darkened with use, and he placed a tablet flat on the center of the conference table and he pressed play. The cloud-saved Zoom recording filled the room. Brennan's entry heavy and deliberate. Leon's questions polite and specific. Leon's hands flat on the oak table, fingers spread entirely visible, entirely still. The sudden violent lunge from behind. The crash of the table. The cracked phone skidding across the floor and settling into its new angle. The audio of Leon stating clearly and repeatedly that he was not resisting. And then the audio of Brennan reading from the confidential folder in a voice that projected toward his own body camera with the practiced direction of someone performing for a record. Reeves paused the video. The frame on the screen showed Brennan's boot planted on the hardwood floor, approximately 18 inches from Leon's head, and superimposed in Calloway's mind over that image was the phrase from the written incident report. The suspect swung his arms aggressively toward this officer. Calloway's gaze moved from the frozen screen to the printed report in the open file in front of him, and it settled on that phrase, and it stayed there for a long time. He picked up the plea agreement. He folded it in half slowly with the care of someone doing something deliberate. He slid it back into his folder. The state dismisses all charges. Calloway said, his voice carrying the particular flatness of someone who is containing several things at once. With prejudice. We're done here. He stood up and left without additional conversation. The city attorney's office sent a moving truck. It arrived at Reeves's firm on a Tuesday morning, and the workers unloaded 55 bankers' boxes of police records onto the sidewalk in front of the building, 12 years of Officer Brennan's use of force documentation filed in response to Reeves's subpoena, organized in no discernible order. A document dump so large that it required 2 trips on the firm's elevator and a temporary reorganization of the conference room that displaced everything else for the foreseeable future. It was a well-established tactic, old and cynical and effective, designed on the principle that a legal team with finite time and resources confronted with an overwhelming quantity of disorganized material would be forced to work so hard just to find what they were looking for that the search itself would become the punishment. What the city attorney's office had not fully accounted for was that Reeves had called in Leon and 6 other law students, and that law students approaching the end of their training have a relationship with dense, disorganized documentary evidence that the city's strategy had not quite anticipated. They worked in shifts spreading across the conference room table and the floor and the 2 folding tables that someone brought up from the storage room, sorting chronologically, and then by incident type flagging use of force reports and setting aside everything else. On the 4th night at approximately 11:30 p.m., with 3 empty pizza boxes in the corner and the kind of tired that sits behind the eyes, Leon pulled a report from a traffic stop in 2019 and read the narrative section. He set it down very carefully. He pulled another from a jaywalking arrest in 2016. He read the narrative section. He set that one down next to the first. He pulled a third from a noise complaint in 2021 involving a 71-year-old man. The suspect became visually agitated upon first contact and refused to comply with lawful commands. When this officer attempted to conduct a lawful identification check, the suspect swung his arms aggressively toward this officer, necessitating a physical takedown to secure the scene. Word for word. Punctuation for punctuation. The identical sentence applied to 3 entirely different people in 3 entirely different situations across 5 years, as though reality had been made to fit the language rather than the other way around. Leon looked up at Reeves, who was standing at the other end of the table reading something else, and Reeves looked back at him, and Leon didn't say anything because there wasn't anything that needed to be said. He just held up the 3 reports in a fan, and Reeves crossed the room and read them. and then they searched the remaining boxes with that specific sentence as the search term, and by 2 in the morning they had found it 58 times. 58 incidents, 12 years, 58 different people in 58 different situations, all of whom had supposedly made the exact same aggressive movement and required the exact same physical response described in the exact same words, down to the comma placement. Leon set the 58th report on top of the stack and looked at it for a long time without speaking. The deposition room at Reeves's firm was small and deliberately neutral. White walls, a rectangular mahogany table, a camera on a tripod in the corner with a red recording light, a court reporter in a gray blazer sitting at a separate, smaller table with her fingers poised above her machine, and 4 people arranged around the main table in the geometry of opposing positions. Brennan sat across from Reeves with the city's attorney, Patricia Cole, a woman in her mid-50s, with the carefully composed expression of someone who had learned to be unreadable positioned to his left. Leon sat beside Reeves not as a witness, not as a participant in any formal sense, just as the person at the center of this particular story, and he had decided before walking in that he would not speak during the deposition, because everything he needed to say was already in the record, and his job today was simply to be present while someone else said the rest of it. Reeves established the oath. He asked Brennan to confirm he understood he was testifying under penalty of perjury. Brennan confirmed it. Reeves pressed play on the laptop, and the Zoom recording filled the room again. He paused it on the frame of Leon's hands flat on the table, and he asked Brennan whether at any point during their interaction in the library, Leon had swung his arms aggressively toward him. Brennan said after a pause that was approximately 1 second too long, that the phrase in the report had been an error of articulation caused by elevated adrenaline in the moment of writing. Reeves nodded, as though this was a perfectly reasonable answer, and reached into the banker's box beside his chair. Exhibit A was from May of 2016. A traffic stop, and Brennan read the highlighted sentence in a voice that was controlled and flat. Exhibit B was from September of 2019, a jaywalking stop, and Brennan read the same sentence in a voice that was slightly less controlled and slightly less flat. Exhibit C was from February of 2021, the arrest of a 71-year-old man on a noise complaint, and Brennan stared at the highlighted text for a moment before reading it, and his voice, when he read it, had become something that was working very hard to remain what it was. Cole said, "Objection relevance in the automatic tone of someone who knows the objection won't land but is required to make it." Reeves said without looking at her, "It establishes a pattern of fabricated documentation and placed exhibits D, E, and F on the table in sequence. A 2017 loitering arrest, a 2020 disorderly conduct stop, a 2022 broken tail light," and Brennan read the same sentence from each of them. 6 different people across 6 years, supposedly all doing exactly the same thing in exactly the same way, requiring exactly the same response, described in exactly the same words. Then Reeves picked up a bound binder that was 4 inches thick containing the remaining 52 reports, and he placed it on the center of the table, and the sound it made was the particular sound of something heavy and final. Mr. Brennan Reeves said, "Over 12 years across 58 separate incidents, you authored use of force reports containing this exact sentence word for word. Is it your testimony that 58 different people in 58 different situations all exhibited the same aggressive motion requiring the same physical response?" The room was quiet. Brennan looked at Cole. Cole looked at the table. There was no objection available that could improve his position. Every direction from here led somewhere worse, and Cole was experienced enough to know it, and the silence on her end of the table communicated that more clearly than words would have. Brennan turned back to the camera. "On the advice of counsel," he said in the voice of someone who has arrived at the end of a road and found exactly what they expected, "I invoke my Fifth Amendment right against self-incrimination." Reeves nodded slowly once, in the manner of someone who had been waiting for this particular word with the patience of someone who understood exactly what it would mean when it arrived. In a civil deposition invoking the Fifth did not confer the same protection it did in criminal proceedings. The jury would be permitted to draw an adverse inference from the refusal to answer, which meant that functionally, in the space of that single sentence, Brennan had done more damage to his own case than anything Reeves could have done to him. Leon sat beside his attorney and did not move and did not speak, and after a moment he allowed himself one very small, very controlled nod, the kind that you give to something that has resolved itself exactly as it needed to. "Deposition concluded," Reeves said, and turned off the camera. The next morning, Reeves served a deposition notice on Sergeant Dale Morrison, who had been Brennan's direct supervisor for 9 of his 12 years on the force, and whose signature appeared on 44 of the 58 fabricated reports, stamped in blue ink beneath the word "Approved." Morrison arrived at the deposition with Cole, who had spent the previous evening attempting to identify a legal strategy that could navigate what was in structural terms an inescapable dilemma if Morrison testified that he had reviewed the available footage before signing each report he was admitting to approving documentation he knew to be false, which made him an active participant in the fabrication. If he testified that he had not reviewed the footage, he was admitting to 12 years of negligence so profound that it demonstrated exactly the institutional failure Reeves needed to prove his broader case against the department. There was no third option. Cole had looked for one and had not found it. Morrison looked at the stack of 44 reports with his signature on them. He looked at the camera. He looked at Cole, who remained expressionless. On the advice of counsel, Morrison said, "I invoke my Fifth Amendment right against self-incrimination." Over the following 48 hours, Reeves deposed 2 additional patrol sergeants and the precinct lieutenant. Each of them sat across the same mahogany table, faced the same bound binder, heard the same question, looked at the same camera, and gave the same answer. The entire supervisory chain, from Brennan's immediate sergeant to the lieutenant who had overseen the division, declined to answer under oath whether they had done their jobs. Because deposition transcripts are public record, the documents were available to anyone who wanted them by Thursday morning. By Thursday afternoon, they had reached the underwriter for the city's liability insurance carrier. At 2:15 p.m. on Thursday, a courier arrived at the mayor's office with a letter on the insurance carrier's letterhead, and the mayor read it standing up, which was not how he usually read things. The letter informed him that based on the deposition transcripts, which demonstrated not an isolated incident of officer misconduct, but a documented decade-long pattern of fabricated use-of-force reports that had been repeatedly approved by supervisory personnel. The carrier had determined that the conduct fell outside the scope of the policy's coverage provisions for the Leon Grant lawsuit, effective immediately. It further informed him that the carrier was issuing a 30-day notice of policy cancellation for the department's entire liability coverage, meaning that within a month, absent a replacement policy which, given the circumstances, would be extraordinarily difficult and expensive to obtain, the department's patrol vehicles could not legally operate. The mayor called an emergency closed session of the city council that evening. The conversation in that room lasted 4 hours and did not produce anything resembling a solution. On Monday morning, 2 black SUVs parked in front of Central City Police Headquarters. The attorneys from the Department of Justice who walked through the lobby did not stop at the front desk. The FBI agents who accompanied them went directly to the server room, presented a federal warrant, and locked down the department's email and dispatch servers. Not a threat, not a warning, just the immediate physical preservation of evidence in a case that had become something the federal government considered worth preserving evidence about. The chief of police read the DOJ notification letter in his office alone, and then he opened the bottom drawer of his desk and removed a single sheet of department letterhead and wrote 1 sentence on it in his own hand, and called his assistant in to witness it and signed it, and that was that. By 6 p.m., the precinct was operating without a chief of police and without liability insurance under federal investigation, with its servers locked down by the FBI, and the mayor had run out of people to call except the one person he had been avoiding calling. Reeves's phone rang at 8:14 p.m., and the number on the screen belonged to the mayor's direct office line, which meant the mayor was calling without going through his legal team, which told Reeves something important about the state of things before the call even connected. He put the phone on speaker and set it on the desk between himself and Leon, who had been sitting across from him for the past hour working through a legal pad of notes and who now set down his pen and sat back in his chair listening. The mayor's voice was clipped in the way of someone who has had a very long and very bad day and is trying to conduct business despite it, and he said that the DOJ was in his building and his insurance was gone, and he needed to know how to end this. Reeves slid a single printed sheet across the desk to Leon, and Leon picked it up and read it, and Reeves looked at him and Leon gave a small deliberate nod. 3 terms, Reeves said. The first, $8.5 million paid from the city's operating fund, transferred within 24 hours of the signed agreement. The mayor said they didn't have it. Reeves said to find it. The second, no non-disclosure agreement. The settlement, the evidence, the deposition transcripts, the 58 reports, and the Zoom recording would all remain in the public record, and Leon retained full rights to publish, distribute, and discuss every piece of it. The mayor said that making those reports public would trigger additional lawsuits. Reeves said that the supervisors shouldn't have signed them. The third, the city would agree in advance to a federal consent decree placing the department's use of force review process under independent external oversight for a minimum of 5 years. The mayor was quiet for 10 seconds, and in those 10 seconds you could hear, if you were listening, the specific sound of a set of options collapsing down to one. "Jenkins will draft the paperwork," the mayor said. "We'll expect it by 9 a.m., Reeves replied. The line disconnected. Leon picked up his pen. Then he set it back down. He looked at the phone for a moment, and then he looked at Reeves and he said, "What happens to the 58 people?" Reeves said, "That's what the public record is for." Officer Daniel Brennan cleared out his desk on a Friday morning, which was the kind of timing that suggested someone in administration had made a deliberate decision about when to schedule the clearance in order to minimize the number of people who would be present to witness it, though as it turned out, the bullpen was not as empty as whoever had made that decision might have hoped. He placed a coffee mug, a small framed photograph, a handful of pens, and a phone charging cable into a cardboard box, and he did this methodically without apparent rush, as though the deliberateness of his movements could impose a certain dignity on the situation. And then he picked up the box and carried it across the bullpen, and there were 14 officers and 2 sergeants in the room, and not one of them spoke or stood or offered anything at all. No handshake, no goodbye, no acknowledgement of 15 years in either direction, just a room of people who had made a collective decision to let someone walk out of it without comment. He handed his keycard to the desk sergeant and pushed through the double glass doors and walked out into the parking lot, and the doors closed behind him, and that was the end of a career. His name had been entered into the statewide Brady List, the database of law enforcement officers whose credibility had been so thoroughly compromised that they could no longer be trusted to testify in criminal proceedings, which meant that he was permanently ineligible for employment in any law enforcement capacity and in any private security role that required court-admissible testimony, which was most of them. Because Brennan was now an invalid witness in every case he had ever touched, the district attorney's office spent the following week reviewing every pending criminal case in which he was the primary arresting officer, and by Friday afternoon they had quietly dismissed charges in 34 of them. 34 people who had been waiting for trials that would now not happen. 34 situations that the system had been carrying forward, based partly on the word of a man who had just invoked his constitutional right not to answer whether he had told the truth. At Reeves's office on a Wednesday afternoon, 3 days after the settlement signed, a woman named Carol Simmons walked in without an appointment and asked to speak with whoever represented Leon Grant. She was the staff member who had made the phone call from the library circulation desk. She sat across from Reeves's associate, and she said that she had watched the video many times and that she had not been able to sleep properly since the night she first saw it, and that she wanted to make a formal statement for the record, and that she wondered if Leon was willing to apologize to him directly. Leon met with her the following day in a small conference room. She told him she had seen a young black man with a lot of folders and a phone set up, and had told herself a story about what that meant before she had asked a single question or learned a single fact, and that the story she had told herself had been wrong in a way that had caused real harm, and that she was sorry in a way that she acknowledged didn't fix anything but that she hoped he would accept anyway. Leon was quiet for a long moment after she finished. Then he said that he accepted it and that he hoped she would keep paying attention to the stories she told herself when she saw people she didn't know, because that was the place where all of it started. She nodded. She left. She later provided a full voluntary witness statement that corroborated every aspect of the video evidence. At 10:03 a.m. on the Tuesday after the settlement was signed, an electronic confirmation landed in the trust account of Reeves and Partners, recording the receipt of $8. $5 million from the Municipal Operating Fund of Central City, and at almost exactly the same moment, a federally appointed independent monitor walked into the lobby of Central City Police Headquarters, bypassed the front desk, and moved into a converted office that had been prepared for her adjacent to the Internal Affairs Division, from which she would, for the next 5 years, review every single use of force report filed by every officer in the department before any supervisor was permitted to stamp it approved. Leon did not buy anything with his share of the settlement money in the first week. He did not throw a party or announce anything on social media or give an interview. He deposited it, and he went back to class because he still had a degree to finish and he had always intended to finish it. 3 weeks after the wire cleared, he stood on a sidewalk 3 blocks from the county courthouse holding a set of keys in his hand, looking up at a 2-story brick building with a temporary banner across the front door that read, in large blue letters, Grant Civil Rights Legal Clinic. Inside, the space was empty, except for a folding table and 2 chairs that Reeves had helped him carry up from a van that morning. Leon set his laptop on the table, the same laptop from the library, the one that had been open to a clinic memorandum when Brennan walked in, the one that had been sitting on the table with his hands flat beside it, and he opened the browser and he navigated to a public cloud directory, and he dragged into it the raw Zoom footage, the 58 fabricated reports, and the complete unedited video of Officer Daniel Brennan, invoking his Fifth Amendment rights in a civil deposition. He looked at the files in the folder for a moment. He clicked Publish. Within 45 minutes, the first wave of civil rights attorneys across the state had begun downloading the files. Within an hour, 2 of them had called Reeves's office about former clients whose arrests had appeared in the 58 reports. The evidence that had been assembled to tell one person's story was already beginning to tell 58 others. The door opened and Mia came in holding her mother's hand, because her mother had seen the news article and had mentioned it at dinner, and Mia had said she knew that person that was the man from the library and had asked if they could go. She was carrying a folded piece of paper, and when she saw Leon, she walked across the empty room and held it out to him with both hands the same way she had held out the fallen document to Brennan on the afternoon this all began, that same uncomplicated directness, that same complete absence of anything other than the intention behind the gesture. Leon unfolded it. It was a drawing in green pencil, a building with large windows that might have been a library, a figure standing beside a table and across the bottom in careful capital letters with the E written backwards the way 9s sometimes do it. Thank you. He looked at it for a long time, and then he looked at Mia, and he said thank you back, and he meant it in more directions than he could have easily explained. The consent decree was signed on a Friday and filed in federal court the following Monday, And what it meant in practical terms was that for the next 5 years, not a single use-of-force report in the Central City Police Department could be approved by an internal supervisor alone. Every incident required a review by an independent external auditor with no institutional relationship to the department, which was a structural change of a kind that does not make headlines, but that quietly and permanently alters the conditions under which a particular kind of harm can occur. 2 months after the decree was filed, the state legislature passed a new requirement that body cameras must begin recording the moment an officer exits their vehicle, eliminating the buffer delay that had allowed the first 2 minutes of the library encounter to go unrecorded, and the attorneys who had pushed for that change cited the Grant case in the floor debate by name. 58 people whose records carried the residue of Brennan's fabricated reports were formally notified of their right to petition for expungement, and legal aid organizations across the state coordinated to make sure that as many of them as possible had help navigating the process. The Grant Civil Rights Legal Clinic received 212 inquiries in its first week of operation, the majority of them from people who did not know they had rights that had been violated, which turned out to be its own kind of evidence about the scope of what one officer over 12 years with 58 approved reports had actually done. Professor Harland Webb updated his course syllabus that fall to include the Zoom recording as a primary teaching document, not as an example of police brutality, though it was that, but as an example of what it looks like when a person holds their ground with their hands flat on a table and their voice steady and lets the record build itself around them, and what that kind of discipline, that specific, trained, deliberate calm, can eventually cost the people who mistake it for weakness. 6 months after the clinic opened, Leon went back to the library. He returned his overdue hold, paid the fine at the circulation desk without irony, and carried his laptop and his backpack to the corner table. The same corner table with the power outlet near the right-hand wall and the window that threw light across the screen without a glare. And he sat down and opened his computer and worked for 3 hours without anyone approaching him, without anyone asking what he was doing there or how long he had been sitting, without anyone making a phone call about a description or a complaint or a story they had told themselves before they knew enough to tell it accurately. The fluorescent lights hummed at their low, familiar frequency above him. The air smelled of old paper and cold air conditioning. Someone somewhere in the stacks was rolling a book cart across the linoleum. The library was peaceful in the way that things are peaceful when they are simply and straightforwardly what they are supposed to be. And Leon Grant sat in the middle of all of it and did his work, and the green recording light on his phone was on, and this time there was nothing to record, except a person at a table in a public library belonging there quietly and completely, and without any need to prove it to anyone. If this story moved you the way it moved us, share it with someone who needs to hear it and subscribe to our channel, because the next story we tell might be about someone you know.